Yeah, so
Okay.
this is day 5, right, of
Mm-hmm.
our 30 years and 30 days of
Mm-hmm.
Pilates history.
Mm-hmm.
And so we are going to discuss the Pilates trademark and
Mm-hmm.
Romana's involvement. So
Okay,
I
cool.
wanted to just kind of review the difference between a copyright, a patent, and then a trademark.
Mm-hmm.
And
Okay.
so a copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. So if you're
Mm-hmm.
writing a book, as soon as you write something down or put it into a program on the computer, it becomes real.
Mm-hmm.
In copyright law, there are lots of different types of works. So paintings, photographs, illustrations, musical compositions, sound recordings, and so on can
Mm-hmm.
all be copyrighted.
Okay.
Okay.
To add a
Go
couple
ahead, Sam.
things to
Yeah.
that,
So
which,
yeah.
basically what people have to realize is that copyright law, right, changed. There was a copyright 1909 copyright law that had rules and regulations and standards, and then they changed it in 1976. So most people today assume that everything is based on the 1976, and it's not. Anything that was before 1976 basically follows those rules and regulations, which is different. So there are differences, and and that also that a copyright lasts up. I think it's depending on what it is. It's either 70 or 95 years after the original person who created it has passed away. So you get it for long
Yeah.
periods of time.
Yeah. So it's not just during their lifetime, it's after they die for another however many years. Yep.
Right. And then the last thing was that, somebody can create something, but they can sell that, which is basically
Mhm.
what happened. Joe had all that, that stuff, and he sold all that to, well, he didn't sell, but Clara did, because with Joe's will, he left everything that he had to Clara, and then she sold the business and the goodwill and all the stuff that goes with that, including the
Yeah.
negatives and all the other things. So that's how that happens. Because
Mhm.
there's a lot of people who say, oh, how can he own it and all this other stuff? Well, it's because that's what happens. It's still valid. And there's the thing is it's also publish it, to just, if he put it on his walls, that wasn't necessarily copyrighted. Back then you literally had to publish it, and there was a standard to publish. Putting a
Mhm.
picture on your wall didn't meet the standard for publishing. So the majority of what he
Okay.
had, which was on the walls, and so somebody takes a picture, there's a picture of that, and then they say, oh, well, we should be able to use it. Well, that doesn't work that way. That's just not how the law works. So
Right.
as
Right.
far as I
Well,
know,
and
that's my understanding. I could be wrong, but
Okay.
well,
you
the
know
other part of what you're talking about is like all these things about copyright is actually has nothing to do with the trademark,
right,
which is
that's
where
No,
the other
we're
another
thing.
just
thing
trying
that
to make the distinction for
no,
people.
I know, but that's the thing is that like a lot of times like, the conversation will just sort of blend the two topics together,
Yeah.
and they're completely separate subjects.
Right.
Right.
Yeah.
Right.
And yeah. Okay,
Okay.
so
So
then
then, yep. Then we have patents, which
Mm-hmm.
is a type of intellectual property that gives its owners the legal right to exclude others from making, using, or selling an invention for a limited period of years in exchange for publishing and enabling disclosure of the invention. So the enabling disclosure means you have to describe your invention, you have to put it in writing, file the patent with the government. Um, so kind of in exchange for that special right of nobody else can use it or make it, you have to put it in writing. So
Like what
that's
Joe
what a
did.
patent is.
Mm-hmm.
and usually I'm pretty sure that's 17 years. Now,
Okay.
when you apply for it, and by the time you do it, there's ways to make it last longer, but
Yeah.
basically, once it's been approved, it's 17. You get it for 17 years. That's why we have all these generic drugs. After 17 years, anybody can make that drug. Same thing.
Yeah.
Okay.
And we know that Joe patented several pieces of equipment in several
Right.
countries. So
And we
okay.
and we know that Joe also copyrighted a number of things.
Yep.
So
Mm-hmm.
he, and that's sort of the difference, is that it wasn't like he was, people say, oh, he didn't protect. Well, he did. He copyrighted 5
Yeah.
things. So he was astute and
Hmm.
understood copyright, and he copyrighted what he felt he needed to copyright, and the stuff that on his walls, that wasn't copyrighted because it was
Yeah.
on his walls.
And he had no qualms about hiring a lawyer to get it done properly.
That's right.
Yeah. Okay. So then that brings us to what a trademark is. A trademark is an easily recognizable symbol, phrase, or word that denotes a specific product. It legally differentiates a product or service from all others of its kind and recognizes the source company's ownership of the brand. So that brings us to trademarks.
Right. And I think that, that's important because Joe passed away, and when he was living, he didn't feel like he needed, he did copyrights and he did patents, but, and back then it was much more difficult to trademark your name. Now you can put your name in a trademark and you have to sign a letter and do all the, this stuff, but you couldn't do that you weren't supposed to do that back then. Now you can. So the law is not static. Things change, and as things evolve, and cases happen and court cases happen and things like that, things change. So, that's also something to do. So he didn't trademark his name. And then, when Clara was alive, they didn't. But after Clara died in 77, right?
Yes.
So within a couple years, they decided to, they were the source, right? They're obviously the source of that work. They, the owners, which was Romana and Larry Stanton and the investors, Larry was not Larry Stanton, John Steele was the lawyer, right? So they decided to, trademark. He says he didn't, but, there's paper with him, that he definitely knew what was going on and was, as a lawyer, what, you didn't do anything when they're doing that? That's all legal stuff. Yeah, I'm sure.
Yeah.
So anyways, so that's what they did. And they first applied. So let me talk about that. I have the
So wait, can we be a little more clear? So Joe left Clara the business and all the goodwill. Clara died in 1977, and the people who bought the studio and all the goodwill from her are now the people you're talking about.
Yes.
Okay.
Which was basically Romana and John Steele, because the other investors, they didn't have anything to do with the business really. They put money in so they would have a gym to go work. They'd have equipment to go work on and have a place to do it. Right. That's pretty much what it was. So Romana ran the business, and John Steele helped, to a certain degree, but as the legal stuff. So here's the first one, and we are pleased to forward you here. We're here within the original of the above identified certificate of trademark registration granted by the United States Patent and Trademark Office on the on the date above indicated. All right. So here's the letter from the lawyer.
Okay.
And then when you open it up, there's the certificate from the government with the little seal. I mean, it's a copy, but that's what it is.
Yeah.
And then here is the piece that comes with it, and it says right there, you can see it says Pilates right there, right? Pilates.
I mean, it is backwards for us, just so you remember.
Yes, I understand that, but that's why I'm saying it. And so the registration number was 1,202,334. And it was first filed on December 8th, 1980.
Okay.
By the Pilates Studio Corp., a New York corporation, 29 West 56th Street, New York, New York. It was registered on July 20th, 1982. So they filed for it in 80, but they didn't get it for, almost a year and a half.
Yeah.
About a year and a half to get that approval. So that was for Pilates, right?
And that was the studio after they moved out of 939, right?
Right. And so this is what it's for: providing facilities for exercise and physical conditioning in Class 41, USCL 107. And they put first use 1923. Right. So that was the first. That was what they used as
Cool.
That was what they did.
Yeah.
Okay. So then the next one is, let me see, I have it here. Let me see, where is this?
So basically, the trademark was filed 6 years before you had even tried Pilates for the first time.
Oh yes.
Yeah.
Yep. So then the next one, here's this one. This is from the government, right? Front page. And then this one says, it's backwards, but you can see it says, that's 2 words, Pilates Studio.
Okay.
It was filed by the same company. And it was for providing facilities for exercise, physical conditioning in class 41. Same thing. It was filed on February 9th, 1981. So about 2 months after the Pilates. And it was registered September 28th, 1982. So that's, again, a little bit, almost around the same amount of time, about a year and a half.
Yeah.
So that was, those are the, the trademarks that they did. Now, I'm going to show you this. This is, I can't read it. I don't think you can because it's German.
It's in German.
That's pretty cool.
Oh, wait. It was upside down. There we go.
Okay.
Deutsches
Yeah.
Patent, right? So it's a patent, and that was for, let me see, where is this? What's it say here? This is U.S. trademark application serial number for German trademark Pilates and for German trademark Pilates Studio, Mars 1982.
So they filed it in
82.
Germany?
Yep.
Okay.
They also filed for the trademark in Germany.
So that would have been John Steele and Romana again.
Yep, the same paper. Yeah, it's all the same.
Right.
Steele was there until Isotoner bought the business. So Steele was there until 86. Now there's this one. This is from October 1982. It's a letter from the lawyer, and it says, "Please be advised that your above identified trademark application has been assigned a serial number and filing date of September 16th, 1982, the Magic Circle." So they also applied for the Magic Circle, and I can't find it, but I'm pretty sure they had that. I have to look for it again. All right, so that was So that was sort of the trademark, and then Aris Isotoner had to apply again because after 5 years you have to do a certain thing, and then we had to do it. So so it was applied for and they got it, and there's differences. And I think maybe what happened is they may have let this one lapse. So then when they bought it, or maybe Isotoner let it lapse because you had to do it 5 years, and they got it right after that, and they didn't do it. So then they reapplied and got it again. So it had another trademark number. You'll see that when you analyze it, you can see. But they pretty much were keeping the trademark at the time. It was like they bought the business.
It sounds like there was a whole business going on, including trademarks, long before you were a student, but also before you purchased the business.
Well, basically, when I basically followed the footsteps of Romana, Mr. Steele, Larry Stanton, Weetai, everybody before me. Yeah. They sent, and I'm going to show you here. I got a number of cease and desist letters, and they sued people. So they made it sound like I tried to trademark Pilates. No, I didn't try to trademark Pilates. I bought it. And that I was doing all these bad, and I influenced Romana, and before that she was Miss Nice Woman, and she didn't do any of this, and that's just not the case. I mean, they
came out of the blue, and
right. I came out of the blue, and it's me. I'm the bad guy because I came in. I was like, oh, I started to sue people. No, I just followed in the footsteps of those who own the business and the trademark before me. That's what I did. And now what happened was, but when I bought it, Pilates was starting to grow. So I sent more letters than they did because when they did it, there weren't that many people. There were very few. And by that time there was starting to be more. So I had to send more letters, so, but I'm like, here's an example. Let me see, where is it here? This is to Elan, 11674 San Vincent Boulevard, Los Angeles. Gentlemen, we represent Aris Isotoner, which operates a Pilates exercise facility and which is the owner of the registered trademarks Pilates and the Pilates Studio. Copies of the federal registration which have been assigned to our client are attached. It has come to our attention that you are advertising and promoting your services with prominent uses of our client's mark. This is to advise you that Pilates is a trademark for both exercise facility and for exercise instruction services. Your use of the Pilates mark is both misappropriation of our client's rights and misuse of its trademark. We trust you will immediately cease these infringing uses. Cease and desist. That's what this is. And it came way before, and this was from 1986.
Okay.
So again, years before, 6 years before I sent any, letters or anything.
Right.
So typical, same thing.
So then
wait, there's
what
so
else?
much, but so then there's new, that was for what? That was for Elon. Now there was another letter from New Image Kinetic Fitness Programs on Ventura Boulevard in Tarzana. And it basically says the same thing.
Okay.
Right? It doesn't say much different. And then there is one, okay, so let me see here. There's one for the hospital too. Now here's one. This says, Dear Larry, our protest letter to the hospital in San Francisco has been successful. And they and then there's a New Age Journal. They sent something to, I sent stuff to magazines.
Yeah.
I sent, and what's interesting is that the hospital, St. Francis Hospital, they agreed to stop doing it, and then they started again, and I sent it again, and then they agreed to stop again. So it's like, what's that tell you? It's like, okay.
People will try and get away with what they can get away with.
Oh, yes, they will.
So then you bought the business and the trademark.
Well,
you understood the trademark to be valid and active.
Yes. Well, wait. There's another letter I want to read.
Okay.
This is from May 23rd, 1985.
Okay.
Dear Larry, I received a call from Mr. Hyman, attorney representing, I'm not going to, a person, because I'm not sure I should say this or what, but, somebody, and it says, without further ado, he agreed that his client would not in the future use any materials indicating that she was a Pilates studio. He asked that additional agreements we required. I told him it was our understanding that his client was not, in fact, teaching the Pilates method and therefore had no right to use the Pilates name in any fashion. He said that might be difficult from his client's standpoint and questioned whether we were not overreaching. I replied that if his client felt we were overreaching, she had the opportunity to become a test case to determine the extent of our rights. He said he would get back to me.
Okay.
So then in June 16th, 1986, that was May 85. Dear Larry and Romana, I am pleased to enclose a copy of the consent decree executed by Judge Weinstein enjoining this person, I'm not going to say their name, from using the marks Pilates and Pilates Studio except as specified therein.
So they came to an understanding?
Well, they sued her. And then, because this is from the judge. It wasn't just her saying, okay. They took her to court. They said, you can be the test case. Well, she was the test case. They sued her. And she, before, she didn't go all the way, but she, she basically settled and stopped. Similar is like what I did with the, the Institute Inc., which was the Pilates Institute. I sued them and they ended up settling, and agreed to stop using the name and things like that. All right. And then there's another letter to New Age Journal. Okay. So that's sort of, so that's just showing that, there's documents and there's proof that, all these things, the letters to people, the letters to magazines, they taking them to court if they weren't going to do it, no different.
Yeah. So the trademark was very well defended.
They defended it from the very beginning.
Yeah.
So that's really something to think about.
Yeah, definitely.
Yeah. And again, it's just they said, oh, I did this. So now what did happen later on after I bought the business and the trademark, I talked to my lawyer and I'd asked him, can I get a trademark for equipment? Right? Because, and he said yes. So, and I applied and I guess there was, back then there was a standard you had to meet, and I didn't get into details with him. He said I could do it, so I did it. I had receipts from all the business before that were selling equipment from Gratz and stuff, selling from, Willie Nelson, Sinatra, SUNY Purchase, those types of things. And then, Isotoner, same thing. So it was, through that period of time. Right. And Weetie had also made a few sales, not a lot. And that was the problem. The judge said, you had to meet a standard, and I didn't meet it. I didn't really realize it. My lawyer didn't tell me. So she said, well, since you didn't meet the standard, you committed fraud on the trademark office. So that's why everybody says, oh, I'm a fraud, but that's not really the case,
That's not yeah.
Right. And what my lawyer says today is that, like I said, the law has changed. He said today that wouldn't happen because things have changed, because, that standard, over time that's changed. So it's, again,
right.
I thought I was doing the right thing. And that I could do it. And lawyer said yes. I applied for it. I had those receipts. Those businesses had made business, and I said they were doing it since, and we know that Joe sold equipment. And so since the trademark application said 1923, that's what I put for the equipment as well. I said, since 1923, I followed what was done before me.
Right.
So, I didn't get sued. I didn't go to court and get convicted of a fraud.
Right.
The judge said I had, did fraud on the trademark office because of the fact that, I said that I had, sold equipment, that the business, there was equipment being sold, but she just said it wasn't enough. You needed to sell more.
Right. Right.
So.
Well, it sounds like, the background you're giving on the trademark starting from 1980 and the work that they did to try to protect the Pilates trademark was part of the reason why you ended up investing in the business in the first place. I mean, they had established, a trademark, and they had established this business. And if they hadn't, it probably wouldn't have been something that, most people would be interested in purchasing.
Well, let me talk about that for a second. Right.
Yeah.
Let me say something. When I bought the trademark, the lawyer said, it's a 50-50 shot. You may win, you may lose. It's not strong because, how much time had, gone by and other things. And that was part of the reason why I lost it, because, if you don't use a trademark for 2 years, you lose it.
Okay.
And, and Weetie did a little, but the judge said she said he didn't meet the standard high enough to do that. So she said that was that was one of the reasons. Right.
Okay.
So there was, and again, what people don't realize is that the trademarks for exercise studios and exercise instruction was always a federally registered trademark. The only one that wasn't, that I did apply for, was for equipment. And who did that affect? That did not affect all those Pilates teachers. It only affected one person.
Yep.
And that was Kenny Endelman. And, Current Concepts. And that's why that's why all that happened, because he was able to, he wanted to be able to use the name Pilates to sell his equipment. And now I have other documents, if we get to it at some point, where, I have records where I show, I sent a letter to my lawyer saying, I talked to Kenny, we talked about this. I was going to pay him $1,500 a year to have the trademark license for the equipment, $1,500. Come on. It's like, what's that? He's like, oh, he wanted to charge all this money, do all this. That's not what it was. It's just not how it was.
Well, it sounds like, you've saved all this documentation, which is like pretty interesting, because I mean, I know, because, you are a business owner. And at the time, you owned, all the studios and all the things, but you saved all of this information. And I know for me, for my studio, I mean, I throw away, we don't even have paper now, as much. So it's like pretty fascinating and amazing that you did save all of this so that we do have the documentation of what really happened.
Well,
the
part of
paper
it
trail.
is, right. Well, part of it is, again, when I got the archives, I got these documents, but there was like a box full of those documents.
Yeah.
I mean, and there's not thousands and thousands, there was,
Yeah.
Like, all those copyright trademark stuff, that's how thick it is. If you get
Yeah.
a banker's box, there's a lot of, so I
Pretty
saved all the,
significant.
well, I
Yeah.
saved that stuff because it's significant and it's business,
Oh.
that kind of business stuff, the client cards, when there was boxes and boxes and most of them probably didn't live there anymore and all that. That's what I got rid of. So again, that,
Yeah.
I hear that all the time. He threw, the
Yeah.
haters, right? Again, there's a few people out there that just, it's like, I lost the trademark 20 years ago. I moved on. I've done all
Yeah.
sorts of stuff, and they just keep going back to it and going back to it. And and it's interesting because when I'm on social media, and I'll ask them a question that has nothing to do with this, that they're making a statement or a claim or something, and I start asking them questions, and almost invariably, what happens? They don't answer the question. And they're like,
Right.
and you lost the trademark. You're a loser, and you're this, and you're that, and all this other stuff. And it's like, so that's how they get past that. And it's just, to me, it's kind of, it just makes me laugh. It's like, okay, so you're not going to answer the question, which is a valid question. And
Yeah.
instead, you're
And
going to
that's
try
why
to
we're doing
make me
this.
look bad. Well, that's part of it, yes, so that people understand. This is what happened, and this is the reality. And it's not that the dialogue that was promoted by Current Concepts and the PMA and everybody else to make me look bad. It was like, oh, he's doing this, he's doing that. No, this is really what happened, and it wasn't me that started it.
Yeah.
So here often, Sean Gallagher fraudulently tried to trademark the word Pilates. So when people say that sentence, it's basically a misunderstanding of what the judge said in the court case at the time. Is that correct?
Yes.
Well, no. Well, yes and no, because she basically said I did apply for the name Pilates for equipment. See, so technically because I didn't meet the standards, she said I had committed fraud on the trademark office. So she did say that. But what people need to understand is that was for equipment only. That was not for, and what they said is what they would say to people was that, if he wins, you're not going to be able to do what you do, which is just not the case.
Right.
You would have had to say Pilates based, and you would have had to maybe, and if you think about it, how many different names are out there now that use, like another name for what teaching Pilates. I mean, it's crazy. So, and again, I always look at it as, the burger joints, right? Wendy's, Burger King, McDonald's, Five Guys, Napkin Guy or this guy or whatever they are. What is it? It's burgers and fries, and they just package it differently. Yep. But it's the same thing. Well, that would have happened to Pilates, and it's already happened to Pilates. You see it now already. And you see with the contemporary and the classical and all this stuff, everybody gets back and forth, and I get it. But in reality, it would have been no different. And everybody says, we got saved. What did he save? The only thing he saved was his ass, and, so he could make millions of dollars. That's the only thing he saved.
Yeah.
In reality. So sorry.
So where are we at now? What's the standing of the trademark now?
Well, when I bought it, I started right away, and got, sending letters and asking people to stop, cease and desist. And what what a lot of people don't also realize is that, like I'd say half the things that I sent were because Romana brought it to my attention and gave me a flyer or a handout or something or an advertisement or something and said, can you take care of this? And I'd say, okay. So, again, I'm Romana, I was the one who influenced Romana. No, she had done that. She's the one who started doing it and was really adamant about trying to protect the name and the work. And, and so when I bought it, I was willing to do that. So every time, I would get things from her all the time, flyers and advertisements, and like, this person's not teaching that. Right. And again, and look what's happened now. We have so much, variance. So I took the trademark, and I basically, what people also don't realize is that when you buy a trademark, you have you do have to protect it. Otherwise you lose it. So you have to send letters. Right. I mean, I guess in hindsight, I guess I probably could have called people and, try to talk to them and, that type of thing.
Some of these people were total strangers.
Well, that's it. So I sent letters. They're in California. I never knew them. It's like, and
Yeah.
and so here's a letter, and I didn't, and it basically said you need to stop, and it didn't
And
say I'm
this
going to
is
sue you
before
right
social
away.
media too, right? So it
Right,
wasn't
right.
as easy to get a hold of people.
Oh no. Oh, of course
Well,
not.
no, I mean, the thing is, if you're going to send, if you have a trademark that you have to defend, I mean, you need to send it in writing. It's not like
It
a
has
phone
to,
call
yeah,
that could
go
be,
through legal channels.
Right.
yeah.
Yeah.
So I had it. That was the other thing. I had, the law requires you to do that.
Mm-hmm.
So it wasn't like, oh, I'm just out about making money. If I was about making money, I would have sold all this stuff for a lot, and not
Yep.
spent all the money trying to protect the quality integrity of the work. It
Yeah.
would have been a
Mm-hmm.
lot easier to work a money deal out, but that's
Yeah.
not, it's not about the money. It never really
No.
was. I
Well,
mean,
I
you
think
have
it,
to have money.
yeah.
You have to have money to run a business. So that, you can't say, oh, it's not about money unless you're a billionaire, and it doesn't matter. I'm not. So, I had to
Yeah.
do those things. But at the same time, it wasn't about just putting it out there. And even today, people are like, can we do this virtually? Can we do that? And it's like, you can't learn some of this stuff virtually. You got to do it hands on. So it's still that way.
Yeah,
Yeah.
I think it's interesting, like you were saying, that part of the reason why it was deemed to be fraudulent was because Weetai hadn't actually sold enough equipment
Right.
at the time. But like the other night, you were saying, your like analysis basically on how he ran the business. I thought was interesting when you said like, he had a lot of like cool ideas, but he was always thinking ahead and he wasn't really focused on what he had, but he was thinking beyond what he had. So I think that's interesting. That's an interesting point that you make, because that sort of is what ended up leading to that moment in the court case. If he had focused on what he had and tried to, sell apparatus or whatever, instead of forward thinking so far and letting that part go, it may have been a different outcome for you.
Oh yeah. Well, no,
Yeah.
because if he'd have done that, he'd have been
Yeah.
successful. So I probably would have bought it. and I would have been doing Pilates-based synergy exercise systems. That's what I would have been doing. Just, so, it's like, okay, you can go either way. I mean,
Which you
people,
did. Yeah, exactly.
which I started to do. And then when I bought the trademark, then I took it the other way. Let me think if there's anything else trademark wise.
Yeah.
I mean, I think that kind of covers it. It basically, I didn't start it. It was done before me 10 years before.
Yep.
Other people, and then, everybody did the same. I just followed in everybody's footsteps. That was
Yeah.
what I did.
Well, I mean, if you think about like, us all, I mean, we're all business owners, right? We're either like, we all either own studios or we're independent contractors or something like, we have our own businesses, unless we teach at somebody's studio as an
Or
employee.
selling books that you've written, I mean,
Yeah.
it's a
Yeah.
business.
So, if you think about your business from start until finish, which for none of us it's finished yet, everything that you do along the way, you're basically running your business to the best of your knowledge. You're being legal and true and following, your lawyer's advice, or doing what you believe you're supposed to be doing for the government and to run your business, honorably. I think
Right.
most of us are doing that, which we believe that we are. So if there's ever a moment in time where you find out, in a courtroom that you've been doing something wrong that you were unaware of, I mean, that could happen to any of us. It really
Yeah.
could. Like sometimes I think about my studio and I'm like, I think I'm doing everything right, but for all I know, there's something that I'm not doing right. And then suddenly one day I'll find out, you are in trouble because you haven't
Right.
been doing this thing. And it's not something that I did knowledgeably, like, to my knowledge, it's just
Right.
something that ends up happening. And it happens
Yeah.
to people all the time, all the
Yeah.
time.
Well, listen, when I ran my business, I always tried to cross the T's and dot the I's and do
Mm-hmm.
everything the right way, because I'm also a medical professional.
Mm-hmm.
And, you have to, I mean, you say you save things. Well, as a medical professional, you were required to save. I mean, I had a storage room
Mm-hmm.
full of patient file. I mean, I had to keep those for 7 years.
Yeah.
Mm-hmm.
And then you get rid of them because, like, you don't need them anymore. They're done.
Mm-hmm.
You don't, and that's the same thing I did with Joe stuff. It's like this old stuff.
Mm-hmm.
But, I had a bookkeeper who
Mm-hmm.
didn't do her job and didn't pay my taxes. And guess who got in trouble?
Mm-hmm.
Wasn't
Not
her. It was
bookkeeper.
me.
Right.
My business. Because
Yeah.
you are responsible as a business
Yeah.
owner to dot the I's and cross the T's and pay attention to everything.
Mm-hmm.
So
Yep.
I always, I did that. I mean, I've had, issues with the business, I had one where I had a secretary, sue my business manager for harassment, and I did all the right things.
Mm-hmm.
I had a manual that talked about how to deal with that, and I did that.
Mm-hmm.
And she still sued me. Her lawyers almost got sanctioned.
Mm-hmm.
I did not. I personally was not found guilty. The business manager lied, so he got in trouble. But so I mean, I always try to do the right things, and if you don't do the right things, guess what? Then you can get in trouble. Luckily, I did the right thing, so I wasn't found guilty for that at all.
Yeah.
So, those are the type of things that happen in a business, that can happen and you don't know about. So I've always tried to be, up front and make sure everything, and if you don't have the records, because when you go to court, what happens?
You have to prove it.
What does Judge Judy say?
They're not going to just take you on
what does Judge Judy say? She says, "Don't pee on my leg and tell me it's raining."
Besides that.
Oh, besides that, she said.
Yeah, it's
what
like
else did she
basically
say?
if you don't have a document, if you don't have documents,
evidence, documentation.
You don't have evidence. Sorry, we can't take it. We can't use it.
If it's not written down, it doesn't count.
And so these documents right here show the actual history, show what really happened. And basically, it's interesting because it would be interesting to see if there was social media back then, if it would have been the same.
But anyway, before we finish, what my point was about that, what I was saying about as all as business owners, is that there's no one event or moment in time that defines any of us or defines us, in business, in Pilates, or in our lives, our personal lives. There's not going to be one thing that happens that just defines you for the rest of your life. And this doesn't define you, the whole situation. People love to use it as a way of just flat out, describing who you are and what you've done. It's like as if that's the only thing that ever happened and that time stood still after that. Right. So, I mean, I don't know. I just have a little bit of an issue, not a little bit, I have an issue with that because that's not true for any of us. I mean, I don't think there's going to be one day in any of our lives that imagine anytime, you're around, people mention, that one thing happened.
Remember what you
gets old.
Yeah.
Well, look, I lost the trademark. I moved on. I focused on my physical therapy business. I licensed, we're going to talk about this too. I licensed the program to a group of teachers and they started a different business. I became, the Cub Master, the Scout Master. I was the volunteer fireman. I was the EMT. My definition, they're like, oh, he's such a bad guy. Like, come and see what I've really done. Yeah. And that's one small piece of it, and how many people have I helped on Broadway? Keeping, I'm the guy in the back. I'm the guy in the back, keeping them together so they can provide the magic out front. Magic out in the back to do the magic in front. So there's all those types of things. So there's lots and lots of things that I've done over the years that, and this is one thing. And
so tomorrow we're going to be talking, Cathy will be talking to you about synergy exercise systems, which I'm looking forward to watching.
Yep,
that'll be good.
There's lots of good stuff there, and talking about
more
how
stories.
How we got together and what happened, and that's the foundation of classical Pilates. It really is. That's
that's cool.
That's I guess the foundation was really Weetai, and I mean it's Joe and everything else, but like that comprehensive training that you get in classical. That's where that all started. So and we'll talk about all that. So watch the recording.
I'm gonna save it in a minute. Okay. All right.
Okay.
Bye.